Welcome to the final lecture on this course. We will be covering a brief look at parental alienation and law in the UK, as well as looking at some of the approaches used in other countries. We're going to begin by evaluating some statutory guidance and proposing how it may be relevant to assessing parental alienation for first instance professionals such as social workers. The intent of the law is often reflected in statutory guidance, which tends to be updated every few years. Currently, the main document guiding the welfare of children in the UK is the Interagency Guidance Working Together to Safeguard Children, and that was last updated in 2018. The guidance defines emotional abuse, starting with the sentence as the persistent emotional maltreatment of a child, such as to cause severe and persistent adverse effects on a child's emotional development. On the next slide, we've taken some of the key phrases from the relevant section of the 2018 safeguarding document and placed them in the left-hand column of the table, with suggestions in the right-hand column as to how these safeguarding concerns may be evident in cases where children are being subjected to a process of parental manipulation. For instance, potential emotional maltreatment could be aligned with parental alienation or maladaptive gatekeeping, both tending to be chronic, long-term maltreatment of a child. And the safeguarding concern of causing severe and persistent adverse effects on a child's emotional development could be matched with adverse behavioural changes are commonly seen in parental alienation cases, and defensive attachment strategies being formed that are beyond a child's healthy developmental range, observable emotional, developmental and mental health issues also lasting into adulthood. The other concerns can be summarised as we go down the rest of the list on the left-hand side of the table. The third safeguarding concern down could be linked to conditional parenting. The fourth, to suppressing or compromising children's abilities to authentically express their views. Then, imposing developmentally inappropriate expectations, such as children deciding whether they will see the other parent. Then limiting and controlling a child's life and psychological experiences. Next down could be linked to exposing a child to harm by their hearing malign perspectives and witnessing and engaging in adverse behaviours towards the targeted parent. Then conditional parenting as a form of bullying that may be physical or emotional. Then instilling false fears into children and exploiting their defenceless situation, especially their cognitive and affective immaturity and vulnerability. The purpose of using the established terminology within the statutory guidance, then matching it to both the established knowledge of the effects of parental manipulation on children and the facts of any particular case, is that it seems more likely that reporting will be effective and that a child will be directed to receive the assistance they need if the appropriate language and recognised terminology are used. The 2018 Working Together to Safeguard Children document defines serious harm as including serious and or long-term impairment to a child's mental health or intellectual, emotional, social or behavioural development. And we've seen from previous lectures that the observations of many mental health experts are that parental alienation would certainly cross the barrier to satisfy the statutory guidance for serious harm. This particular form of parental manipulation has been shown to seriously impair a child's mental health, their intellectual, emotional, social and behavioural development, and their quality of life outcomes. Let's take a look at the statutory guidance used in the United States, the Child Welfare Information Gateway. It defines emotional child abuse in relational terms, stating that Emotional abuse is normally to be found in the relation between a parent-carer and a child rather than in a specific event or a pattern of events. And they go on to say that emotional child abuse occurs when a child's developmental need for affection, approval, consistency and security are not met. The relational perspective seems an effective way of considering parental alienation as emotional child abuse. It's through relational interactions that children become so overwhelmed by negative emotions that they become psychologically ill. For instance, suffering loss, forming maladaptive attachment strategies, becoming triangulated and psychologically enmeshed, and suffering pathological splitting. Each of these psychological illnesses have been shown to have serious effects on child development. The typical language used in the Child Welfare Information Gateway document is that injury to the psychological capacity or emotional stability of a child is evidenced by an observable or substantial change in the child's behaviour and observable changes in their emotional responses or observable changes in their cognition. And we've seen that all three of these requirements to psychological injury to a child are ticked in parental alienation. There are substantial changes in a manipulated child's behaviour. There are extreme and unsubstantiated affect, arousal and emotional responses towards targeted parents. And there are obtuse changes in children's cognition about their targeted parent. And child psychological abuse, a higher legal threshold of harm that is also diagnosable, is indicated within the Child Welfare Information Gateway document as manifesting in a child's anxiety, depression, withdrawal, or aggressive behaviour. Again, all of these potential and common symptoms are present in alienation cases. This may be a useful time to remind ourselves of Dr. Barbara Buckhardt's warnings about alienated children she's needed to work with. The top paragraph on the slide shows how antisocial the children are, and in the bottom sentence, the consequences of failing to reunite children with their targeted parents. These reunifications can fail if not overseen by specialists because they tend to be so severely delayed and may require intensive, skilled intervention techniques. The consequences of failed reunification efforts seen by Dr. Buckhardt are children dropping out of school, drug addiction, other antisocial behaviours, and early pregnancies with very adverse consequences. The Child Welfare Information Gateway document has 11 pointers towards defining emotional abuse. At least 8 of the 11 could meet the criteria for emotional abuse in parental alienation cases. The first is imposing negative attitudes on a child. Again, we have conditional parenting. There's emotional unavailability, especially where facilitating a child's needs for both parents is concerned. There's unresponsiveness to the child's attachment needs with the targeted parent, and prematurely imposing a decision on an immature, vulnerable, pressured, or even alienated child of whether they will continue to have a relationship with the targeted parent. There's unrealistic or inappropriate expectations of a child's capacity to understand how they are being affected by a process of parental manipulation. There's underprotection of the child. That's underprotection from the alienating parent themselves, and overprotection of the child from the targeted parent and the wider family. Where children are isolated, there is a failure to show an interest in their age-appropriate opportunities, and where they are triangulated, psychologically enmeshed and splitting, without providing respite or remedy for the children, there is a neglect or failure to show understanding for a child's healthy cognitive and emotional development. Some researchers and practitioners have gone as far to propose that parental alienation is actually a form of domestic abuse or even domestic violence on a child. It would seem that the government of the Republic of Ireland have also adopted the Child Welfare Information Gateway document as their guidance, and their paragraph 23.2 could be useful for expressing the seriousness of alienation in reports, where they state that emotional abuse can be manifested in terms of the child's behaviour, cognitive, affective or physical functioning. Examples of these include insecure attachment, unhappiness, low self-esteem, educational and developmental underachievement, and oppositional behaviour, all of which are apparent across alienation cases. Oppositional behaviour happens in cases where a child has been manipulated and can initially manifest when professionals try to assist them reunite with the targeted parent. Where this degree of manipulation has been achieved, so high that a child cannot easily reunite with the targeted parent, it should easily satisfy the criteria of child psychological abuse by the alienating parent, not least because of the prospect of a child needing to undergo careful therapeutic assistance. The Child Welfare Information Gateway document proposes that the threshold of significant harm is reached when abusive interactions dominate and become typical of the relationship between the child and the parent. That would seem to satisfy the significant harm criteria for genuine parental alienation cases. Abusive relationships do dominate and do become typical of the relationship. These abusive parental interactions that cause children to have developmental maladaptations tend to be typical of the relationship between a controlling parent and their vulnerable and manipulated children. The threshold for significant harm being met in any case obliges the state to intervene to protect children. So establishing that the threshold of significant harm is reached in parental alienation cases seems a reasonable means by which children could and should be assisted. It has been established in the UK, however, that the significant harm threshold does not have to be met for the everyday care of children to be transferred from an alienating parent. Statutory guidance is good for professionals to help orientate their investigations and reporting, but as yet, parental manipulation or alienation are not specifically mentioned in guidance. Where the law is vague or currently insufficient, it is the responsibility of the judiciary to bridge the gap. In 2014, 3 senior judges in the UK's Court of Appeal stated that this type of parental manipulation of children required protection measures, such as transferring children to the other parent if possible. This is rare, but it's not the first time. What was notable about the judgment, however, is that it equated parental manipulation as just as harmful as physical abuse. The senior judges dismissed an appeal from a mother who had been found to have manipulated her children against their father. The High Court had ruled that they must transfer to live with him. And that in the text of the judgment, you can see the process used by the judges. The court made the relevant findings. The court established the lack of support for the children at home with their mother. There was no protection for the children from the manipulation of the controlling parent. And in ensuring the level of harm satisfies the need to transfer the children, the Lord Justices expressed their view that parental alienation is as harmful as physical abuse. The judgment also severely criticised the professionals in a case, indicating that there would be a lack of professional support for the children if the court left them with the mother. It seems the UK Family Division also wants evidence of the lack of likely change in the controlling parent by the continuance of alienating behaviours and the ongoing risk to the children from a lack of present or effective supports. Under those circumstances, the Court of Appeal felt it unconscionable and untenable not to transfer care to the targeted parent, the father. It is, however, a tragedy that observation of many cases in the lower family court shows that they do not adhere to the legal precedents set in the upper courts, such as the High Court and Court of Appeal. Cases still generally remain in the lower courts for years and may well be mismanaged for some considerable time, with judicial directions that do little or nothing to actually assist the children on the way, and resulting in intense iatrogenic harm done to those children and their families. I'd suggest the Court of Appeal is correct in stating parental manipulation of children against another parent causes a similar index of harm as physical abuse. The long-term evidence suggests it may even be more serious. So, are alienated children protected under the criminal law? Well, unfortunately, no. Policy denies children such protection so far. The relevant statute would be the Children and Young Persons Act 1933. Section 1 of that Act states that children who are ill-treated or neglected or exposed to any likelihood of unnecessary suffering or injury to health, whether it be physical or psychological harm, have suffered a criminal act against them. But statutory guidance does not specifically protect children by potentially criminalising any parental alienation strategy or behaviour other than child abduction. Some campaigners have argued that children should be protected under the same laws of controlling or coercive behaviour that adults benefit from. And here would go to another act, the Serious Crime Act 2015. But Section 76, subsection B of that Act removes children under 16 from that protection. That means the only place children can be protected from the effects of parental alienation strategies and behaviours is the family court, where evidence shows that even if they are to be protected, it will be a very long process before they are effectively helped, if ever. Let's take a close look at other jurisdictions that took stringent action against parental alienation. In 2010, Brazil criminalised parental alienation. Brazilian law is more specific than the UK's, detailing the kind of abuse a judge may decide constitutes the offence. Their statute criminalises interfering with a child's psychological formation so as to promote repudiation of a parent or damage to the establishment or maintenance of ties with a parent by any person who may have a child in their care. A note that the Brazilian law covers any person who may have the child in their care. This covers the issue in the UK where children and litigation can be adversely affected by third parties who are not part of the legal process. The Brazilian law provides guidance on some specific parental alienation behaviours, such as waging campaigns of disparagement against the other parent, hindering the other parent's exercise of parental authority, limiting contact, making the child's right to have a close family life difficult, deliberately omitting relevant personal information about the child from the other parent, making false complaints about the other parent or family members, preventing wider family members from a relationship with the child, and relocation for no apparent purpose other than to hamper the relationship between the child, other parent, and extended family. It's encouraging to see in the Brazilian legislation that a child's connections not just to targeted parents but to extended family have been protected by the criminal statute. So what powers does Brazilian statute provide criminal judges? You could perhaps have images of alienating parents being jailed, but that doesn't seem to be the case. Firstly, family judges have to establish that an act of parental alienation has taken place and make that finding at court. The alienating parent is then warned. The criminal court can direct children spend more time with the targeted parent, and they can direct joint custody or temporarily direct that children live with the targeted parent. And they can fine the alienating parent and order them to attend counselling. Let's take a closer look at the process that Brazilian courts have been provided. Evidence for the parental alienating behaviour would need to be found to the criminal standard and declared as having occurred. The alienating parent is warned, and I'd suggest warnings are of particular importance, especially where there may be naive alienation cases, because in the UK there is a presumption of mens rea that needs to be established, that is, the intentional knowledge of wrongdoing that constitutes part of a crime. If a parent thought to be or claiming to be naive is warned and continues to engage in alienating behaviour, the criminal defence of still being naive is no longer as strong. The powers open to Brazilian judges are interesting, as they transfer authority from the family court to the criminal court for this specific type of child abuse, and potentially there seems some key advantages to the public, and especially to children, of criminalising parental alienation. Firstly, the public are placed on notice of this type of adverse behaviour and its consequences for children. The behaviours are specified and warnings of consequences provided to any person who may have a child in their care. States have an obligation to investigate criminal complaints quickly. Criminal investigations are far less complicated than matters discussed at family courts. It seems sensible to remove this specific issue from family court and deal with it as a standalone problem. There may be more resources in the criminal jurisdiction to investigate and act quickly, and perhaps provide interim protection and assistance to children, rather than these cases languishing in family courts for several years with no interim help for children. Transferring to the criminal courts means the massive burden of proof is removed from the targeted parent and placed on the state's prosecutors. Dealing with parental alienation in criminal courts probably helps to reduce the deterioration of mental health in targeted parents, which seems a bonus for public health generally and keeping the economy healthier with less traumatised people. And presumably, criminal investigators would need to be qualified and specifically trained in parental alienation. Other potential advantages to criminalising parental alienation could include mandated public judgments, and judgments that will be peer-reviewed by others in the criminal legal process. There is currently a huge transparency problem in UK family courts in that not enough judgments in the lower courts are being published. Sir James Mumby, for instance, has campaigned for years for greater transparency, especially that of lower court judges publicising their judgments. They may have their reasons for continuing to withhold their judgments, but Sir James is probably correct when recently stating that some family court judges actually wish to conceal their reasons from the public because they are not adequately managing cases. There are some further potential advantages of criminalising parental alienation. It would remove the legal business model for extended litigation in private family courts that are unseen by the public and unmonitored by the government. Cases of gatekeeping, intractable hostility and parental alienation can especially be badly managed, take far too long to resolve for children. They cost extreme amounts of money and often end with the worst kind of outcomes. And in the UK, there is no economic incentive for early resolution for the private contractors who are plugged into the private family court system. In the UK, part of the reason for the recorded rise of separated parents manipulating their children is because many will know, as will their professional advocates, that parental alienation is an extremely effective legal strategy in the UK family courts. And there's an institutional element to this. Parkinson's law tells us that institutions left to their own devices tend to develop self-serving bureaucracies that expand in size. They take as long as they are given to address matters. If they make themselves new powers and procedures, they tend to increase their own duties and responsibilities, perhaps without always effectively resolving the issues they are tasked to deal with. The family court system in the UK has been largely left to its own devices. It has been roundly criticised in several independent reports and government reviews as inadequate, yet none of the recommendations for systemic improvement have ever been implemented. So transparency would be another good reason for child abuse issues, such as parental alienation, to be dealt with in public criminal courts. Presumably, there will still be some reporting restrictions on the news media, but the public and journalists can normally attend criminal proceedings, so there may otherwise be greater public exposure, greater accountability for the court system, and greater public trust in a court system dealing with issues relating to children. Criminalising parental alienation also means a court is doing what it's designed to do. It separates out a serious and specific matter and deals with it as a standalone issue. It seems criminal courts may be far better focused. For instance, what's the crime? Did it happen? Does it satisfy the statutory definition of the crime? If it did, what's to be done about it? And, as already said, the criminal process is likely to be quicker than a family court one. If criminal courts are able to direct therapies for alienating parents, as they are in Brazil, maybe they could be funded by the state. Their effectiveness could be monitored and best practices developed. It could be a means of assisting parents with personality vulnerabilities who may otherwise not be able to engage with or afford assistance in reorganising to a healthier mental health profile. And lastly, there is the public education that inevitably rides on criminalising any behaviour, so that the proper functioning and purpose of the law, that of guiding views and behaviour, is achieved. The next two countries we will be looking at are Israel and Malta. Both countries have also introduced what seem effective ways of dealing with family separation and parental alienation issues. I'll see you again in the second section of this final lecture in Course 1. Thank you. Welcome back to the second part of Lecture 16 on parental alienation and the law. We'll start by looking at the innovations deployed in the Israeli family courts for the last 26 years. Firstly, however, we need to focus on how the Israelis have constructed their family law statute. A retired Israeli judge, Philip Marcus, tells us that in 1951, less than 3 years after the establishment of the State of Israel, a law was passed saying that the biological parents are the natural guardians of the child, regardless of the marital status of the parents. So, legal guardianship is appointed to both parents in Israel, whether or not they are married. Natural guardianship maintains the legal principle that both parents are the natural protectors of their children. It seems a stronger expression by the state of the accepted necessity for a bond between parent and child than what can be the UK's comparatively weak and sometimes ineffective legal concept of parental responsibility, and the Israeli law applying natural guardianship to both parents regardless of marital status at the time of their child's birth does not proactively discriminate against unmarried fathers. The natural guardianship laws were never since changed in Israel, despite pressure from lobby groups to change to the same parental responsibility concept as operates in the UK. But it seems that in practice, parental responsibility is a very poor cousin to natural guardianship. It seems the experience of most targeted parents that parental responsibility in the UK is a legal concept that sometimes is ignored by authorities and does not work well at all in the real world. As Judge Philip Marcus says, where natural guardianship exists, it seems difficult to justify a state's construction of law, policy, legal procedures and child welfare practices that do not respect a child's contact to either of their parents. In 1995, the Israelis took another large step. Significant legal changes dispensed with the civil, adversarial dispute style of family litigation that is so damaging and perhaps senseless in other jurisdictions. The changes in legislation came on top of fundamental legal necessities to actively promote rather than inhibit the engagement of two good parents with their children. However, the Israelis retained the tender years doctrine of children living with their mothers throughout infancy and beyond until the child reaches the age of 6. Mothers are prioritised over fathers in the early years unless the arrangement is otherwise shown to not be in the child's best interests. And Judge Philip Marcus wrote in 2018, he wrote an article explaining the functioning and the successes of the Israeli family court system. The system had by then been in place for 23 years, and the aim of the new system set up in 1995 was to ensure a greater link between the helping professions and the family judiciary, and to apply an effective early interventions and resolutions framework to family separation issues. Cases were only to go to court if absolutely necessary, at which point judges would already be advised with experts having investigated the case. So why did they do it? Well, there was an emerging realization in Israel that families and their children were suffering because of adversarial litigation in cases of this kind being conducted as ordinary civil disputes in terms of your rules of evidence and procedure and without sufficient regard for families' welfare. In Israel, new family court social service units were then formed as first contact early intervention teams for investigating family separation issues before they went to court. But let's just pause there. We know from experience in the UK that it's not enough to simply append a social service unit to the court system and expect these kind of delicate issues to be efficiently, effectively and expeditiously managed. There is an obvious and distinct need to ensure that first instance assessors are very highly trained and experienced in relevant areas such as attachment, family systems and mental health, and that their work is monitored to ensure they are genuinely acting in the best interests of children. Those steps, arguably, have not been adequately put in place within the UK family court system. For instance, recently there has been a refusal by units within the Ministry of Justice to cooperate with government and senior judicial efforts to introduce guidance in relation to parenting time for children, the single foremost issue causing applications to private family courts. In Israel, however, only senior social workers who were also highly experienced in family therapy and allied areas were appointed to their family court social services units. The Israeli court service teams also have access to psychologists and psychiatrists. Lawyers have been added to the teams as well. Teams are attached to every court and based nearby. And these teams promote settlement of conflicts. They assist both the court and the families in crisis. They act in the interests of all family members and of children in particular. They assist families in litigation to settle their conflicts outside of the court, and they help curtail the adversarial process. They address the emotional, personal and interpersonal needs of the litigant and the family, and they improve parenting skills. Over the years, the mandate of the Israeli court service units has expanded. Initially, they assessed and gave advice and assistance to litigants in the court, but they soon went into mediation and referrals for therapy. These services are free of charge to the parties, no doubt cutting out a huge degree of forensic and financial stress for families. And judges in Israel can be assured before sitting on a case that parents have received all relevant education and attempts to keep them out of court. Only the cases that really need to go to court actually do. And using this approach, the huge degree of unnecessary suffering can be avoided or mitigated. Efforts can be focused on resolution instead of adversarial litigation. The service is confidential, which would seem beneficial in two ways. One is that therapy is assisted where it is confidential, rather than its details and personal disclosures being shared with the court and other parties. It also helps therapists be assured that their service is ethical. Another reason for confidentiality may be to prevent what I once saw in a case in the UK. A divorcing couple had agreed that their 3 mixed-aged daughters should live with their father. The 2 eldest children were then alienated against their mother. The youngest child, a teenager, had been secretly communicating with her mother via apps on her mobile phone. The mother told this to a court welfare reporter and asked her not to tell anybody else. The reporter ignored her and placed it in the court report, and both parents saw the report. The day the report was issued was the last day the teenage girl had any more contact with her mother. The court welfare reporter then went and recommended to the court and obtained an order that the father not be obliged to provide any further contact between any of the children and their mother. Some confidentiality in this case, and perhaps many others, would have been appropriate rather than applying rigid procedures and outcomes that are clearly not in the best interests of children. One very important factor to note is that the Israeli family court service units are nested under their Ministry of Welfare. This presumably adds to the credibility of the units, as they must then function with the best practice towards public health, and are far more likely to do so. There would be greater accountability for practitioners if nested under a ministry with a mandate to promote public health. It also means that the judiciary are more securely linked to making decisions in the best interests of a child, because child and family health are the basis of the recommendations made by the units. If nested under the Ministry of Welfare, there is more likelihood of peer-reviewed team practice, plus research of outcomes and requirements to demonstrate their procedures are updated in regards to best practice. This would mean that families and courts are provided an up-to-date, cutting-edge service, so Israeli judges can genuinely decide in the best interests of children. Now, by contrast, Kafkas was nested under the Department of Education and is now under the Ministry of Justice. Neither of these UK ministries have mandates for public health. The Israeli service units can also incorporate all of the elements that are mostly contracted out at huge cost to families in the UK. Visitation centres, family violence treatments, other treatments, parental education, counselling and mental health specialists are all incorporated into their court welfare service, and it's all free. Incorporating mediation within the service and being near the court is also far more sensible and aligns with the best practice and outcomes studied in different mediation frameworks. For instance, Dr. Robert Dingwall's study in 2011 shows mediation simply does not work without it being informed by other services and with the court able to make swift directions once progress is agreed in mediation. In Israel in 1995, the law mandated specialist family judges who, in order to be appointed to the family court bench, are required to have knowledge and experience in the family law field. They are also required to attend topic-related residential seminars every year to ensure they are up to date with academic and therapeutic issues. And, as with any other type of profession, Israeli judges also hold in-service training seminars. It's recorded that over the years there have been successful joint seminars for all judges who deal in the various courts with family matters. The application process in Israel is also different. Parents cannot apply direct to the court, but instead for a dispute resolution process that invokes the services of the family court support service units attached to that particular court. The service unit arranges meetings for information, assessment and coordination. Children are interviewed in confidence and given emotional support. There are early investigations of domestic abuse or domestic violence and swift investigations of allegations of child abuse and child alienation. The Israeli court service units also advise parents when their equivalent of non-molestation order applications are made to court. The allegations are scrutinised. Are they one-off incidences or typical occurrences? Is there a real need for this form of protection? The consequences for the respondent to the non-molestation order are also made clear to the applicant before proceeding. Like in the UK, injunctions such as non-molestation orders can be sought ex parte or without notice to a respondent, so they don't know about them. If directed by the Israeli court, however, those court orders can only be issued for an interim basis of 7 days. Statute obliges courts that the matter must return to court within 7 days. The service unit intervenes to ensure that children see both parents safely in the meantime. This seems far better than the UK legal drafting that only requires courts to list return hearings where they are contested, and even then only as soon as possible. And I've known that process to take 1 year or even longer if the initial allegations are incorporated into further litigation. Or sometimes initial allegations are never adjudicated at all in the UK, with the non-molestation order nonetheless staying in place throughout, causing immense upset and stress to the respondent, denied their chance to contest a serious order, risking their liberty, and made against them, sometimes without any allegations being adjudicated first. But the real test of any family court system is how well children are catered for when one of their parents is intractably hostile, or there's maladaptive gatekeeping, or parental manipulation and alienation cases, or there's any combination of these. Here, the Israeli Family Court Service units proactively acknowledge the prevalence of mental health vulnerabilities in this sample of parents and the serious distress for children. And this is a huge, important and pragmatic step where the likelihood of one or both parents with these type of family separation issues having significant mental health problems is accepted, with the first instance team being specifically trained in this area of mental health. So in Israel, there's a watchful lookout for alienation strategies and behaviours. The court has immediate powers to cut child support where a child's resist, refuse, reject behaviours are unfounded. This would deter many alienating parents at the lower end of mental health issues and perhaps prevent it being used as a legal strategy aimed at resource seeking. Some children will be assisted immediately in any court process because parents who deny contact for the purpose of gaining greater child maintenance may actually have it cut until some contact is restored. Another huge, important and pragmatic step is that the Israeli statute has defined contact failure as meeting the threshold for significant harm. So, where contact failure is apparent, the state has an obligation to intervene. Practice is based around the presumption of ongoing and increasing harm where contact failure is evident or risked. Where there is a serious risk of actual event of contact failure, the unit can recommend judges immediately make unequivocal orders directing contact with strong sanctions for non-compliance, including imprisonment, fines, and temporarily removing a parent's decision-making authority. And it seems the Israeli judges are quite serious in applying these powers. Parents can also be directed by the court to undertake specific education provided by the service units in parental alienation and its effects on children. This can serve to correct naive alienating parents and remove them from the naive category once they're educated. So early on, some children are assisted by a change in some of their alienating parents because the education will make them aware of how their behaviours affect their children. These proactive measures presumably result in only the most serious of cases going to court. With Israeli courts not inundated and overwhelmed, serious matters can be dealt with rather more quickly, especially when the court has a social work and therapeutic team on hand to immediately enact whatever therapeutic jurisdiction directions are considered necessary. And where judicial directions are made, the Israeli court's social service units can monitor compliance. And a really important provision for children has been catered for in Israel. Where legal proceedings have to happen, it doesn't mean children are forgotten and left without support for years, like they often are in the UK. Ongoing child therapy can be provided to help children cope with the new situation and the pressures they face. And where a parent doesn't comply with a child's therapy, their decision-making authority as parents can be suspended. And as you saw from the earlier lectures, denying children the right therapy or failing to engage in the correct therapy to prevent their children's assistance and progress is a serious alienating strategy with its own set of behaviours. So these established Israeli changes at family courts all make for a more realistic and effective family court system that proactively understands this particular sample of parents and their effect on children. It recognises and seeks to prevent the damage to the wider family and on wider public health of contact failure. In the UK, contact failure is not treated as an urgent issue at all. Further, the Israeli approach may well prevent the intergenerational spread of mental health issues within and further down the family trees of many thousands of families. So that's Israel, theoretically at least, a model of excellence. Malta is the latest country to take meaningful action against parental alienation. in two ways. One is by including it as a form of significant threshold child abuse, and also placing that within new laws of mandatory reporting. Mandatory reporting is the concept whereby particular individuals, often professionals, in contact with children are obliged by law to report knowledge or strong suspicions of child maltreatment. There are at least a dozen countries leading with mandatory reporting, aligning with those states' obligations under Article 19 of the United Nations Convention on the Rights of Children. So far, the UK is not one of them, despite being signatory to the same convention. In Malta, reporting of child protection matters is legally everybody's responsibility. So members of the public, teachers and first instance social workers would have to report suspicions of parental alienation as child abuse. The matter would then likely be handled in public law courts rather than in private law. And page 8 of the Maltese statutory guidance places parental alienation under vicarious abuse because it intentionally harms another person through the child and harms the child being used as a proxy within that process, whether the potentially severe affective and cognitive harm on a child is intentional or not. Here, the Maltese government has accepted in statutory guidance the damage done to targeted parents and seeks to protect them, and accepts the harm done to immature children being used as proxies. That concludes our lecture on parental alienation and the law, where we showed some of the different attitudes and approaches taken towards parental alienation by other countries and how they contrast with the UK. And that also concludes the final lecture on this course. This course took an immense amount of study and preparation. I'd like to especially thank the clinicians who did the work referred to in the lectures. You've been an inspiration. I'd also like to thank the Association for Family Conciliation and Courts and the Overcoming Barriers team for the excellent work, the support and the reference material they've produced for alienation practitioners. The production crew there behind the camera and they're operating the auto cue have worked tirelessly and doggedly this week, overcoming some very trying obstacles to finish this filming and editing of the course. I'd like to thank Dr. Patricia Crittenden for developing the dynamic maturational model of attachment, a wonderful piece of engineering that has made my life as a researcher and assessor so much easier. And thanks to you, those undertaking this course. We thank you and wish you and all members of your own families the blessing and benefits of developing and maintaining secure attachments. Thank you.